Our next speaker is Andreja Katancevic. He graduated at the University of Belgrade Faculty of Law in 2007. He finished his master's then in Roman law in 2009 and doctoral studies in Roman law in 2013 at the same faculty. And he is currently working at the same faculty as an assistant professor of Roman law. And he will be talking to us about the judiciary transition, the case of Novo, Brdo.
Well, thank you. No. Thank you very much. So, I'm not that young legal historian, so I'll be sitting. So please excuse me for inconvenience. And why Novo Brdo? I guess that nobody here except maybe Valerio knows what Novo Brdo was. Novo Brdo was a city in medieval Serbia. It's nowadays east part of Kosovo. It's 1,000 meters above sea level, so it's really mountain. Translated in English, it means new mountain. And nowadays, it's completely not inhabited. So, no people there living. But in the area around the city, there were many gold and silver mines during medieval, and according to contemporary Byzantine sources, it was the mountain of gold and silver, or the river of gold. Bertrandon de la Brocquière, traveler from the first half of the 15th century, said that yearly income of Serbian ruler only from taxes from Novo Brdo was 200,000 ducats. It means that it was 700 kilos of gold in ducats. So the testimonies are probably exaggerated, but there is very serious thesis which is advocated that approximately 1/5 of the European silver and gold production came from Serbian mines in the period of Hussite wars. So that's first half of 15th century. And the most significant Serbian silver mine at that time was Novo Brdo, which means that most significant European silver mine at that period was Novo Brdo. And that is the reason why there are a lot of sources about Novo Brdo, a lot of preserved sources about Novo Brdo, and the reason why it is possible to trace the transition of judiciary system of Novo Brdo. The beginning of medieval Serbian mining is connected with the settlement of Saxons to Serbian territories. And the Saxons in Serbia are mentioned firstly in the sources in a charter of King Stefan Uroš I. And that charter was issued in the middle of the 13th century. There is thesis that that was 1261, but we can't say sure that that was at that particular year. And for the rediscovering the transition, we have to see what Serbian judiciary system looked like before the Saxons. So there were several types of courts: court of the king, courts of landlords, courts of the church, courts of autonomous municipalities on the Adriatic coast, the mixed court resolving disputes between subjects of Serbian king and citizens of Dubrovnik, etc. But three courts are most important for this story. So the court of the king, courts of landlords, patrimonial courts of landlords, and courts of the church. And let's say something about their jurisdiction. King's court jurisdiction, ratione materiae, was over severe criminal deeds like treason, murder, or theft, and the case concerning church land. Church court's jurisdiction, ratione materiae, existed over cases concerning short list of cases, mostly concerning marriage issues and some other moral deeds. King's, church, and landlords' court jurisdiction, ratione persone, were the cases and criminal deeds of the serfs on their land. And at the end, church court ratione persone jurisdiction was the cases concerning the clergy. And for the better orientation, let's draw it on the table. So, which is very typical for feudal society. I did something bad. No.
It's okay.
Sorry. We have, of course, landlords. Then we have serfs. Then we have clergy. And then we have some severe criminal deeds and cases concerning church land. Then we have some marriage issues. And then we have, of course, the rest of the disputes and proceedings. And now, severe, so the cases about church land and prosecutions of severe criminal deeds for landlords, that was reserved for King's Court. For the serfs, of course, King's Court. For clergy, completely the same, King's Court. Marriage issues, of course, church court in all of those three situations. And the rest, for the landlords, was jurisdiction of the King's Court. For the serfs, was jurisdiction of patrimonial courts, so courts of landlords. And for the clergy, was in jurisdiction of church courts. And now, in the middle of the 13th century, Saxons came. And now, for severe criminal deeds and cases about church land, of course, responsible is the King's Court. That's King's Court jurisdiction. For the marriage and some other moral issues, it's of course church court. Of course, courts of Catholic Church, since Saxons were Catholics. And now, what is the question? What are we going to do with the rest of the cases between Serbs and Saxons and between Saxons themselves? So this part here is disputed. And so, what happened now in the middle of the 13th century? Transition happened. So in Dubrovnik sources, there is a mention of Court of Germans, Curia Teutonicorum, whose jurisdiction is disputed. So nobody knows what was jurisdiction of the so-called Curia Teutonicorum. But it is known that the court was consisted of several judges, mentioned in sources as Council of Purgari. Purgar, that's medieval Serbian word, and actually it's Serbian transcription of German word Bürger, which means citizen. And it is quite obvious that this was collegium of judges, which appears very often in Saxon's customary mining law in the written privileges issued to the mining centers in medieval Central Europe. And this court in Novo Brdo had very interesting development, namely according to the mining law, which is Serbian codification of mining law issued at the beginning of the 15th century. the members of this collegia were not only purgari, not only the birga, but also local archpriest, Orthodox archpriest, and knez. So knez is local, probably autonomous authority present at all towns and villages in medieval Serbia. And the first question which arises from this fact is, was there a privilege issued in order to establish these courts for this part of jurisdiction here? So although there is thesis that these courts were established by written charter, there is no single mention of such charter in sources of any kind. And second question is, were only Saxons under the jurisdiction of the Council of Purgari? So the answer may be found in the mining code of Despot Stefan Lazarevic from around 1400. And that code passed on request of the city council of Novo Brdo. Although mentioning the Council of Purgari, the code does not mention term Saxon, Sas. No mentioning in this code. Even in the introduction of the charter, the persons with German names were mentioned, like Pippin, for example, but not as members of an ethnic group. One may assume that all minors have equal rights independently from their ethnicity or religion. As I mentioned, Saxons were Catholics, Serbs were Orthodox, etc. So, for the second time, there was a need for intervention in the structure of judicial system in Brdo at the beginning of the 15th century. And this intervention was double. This intervention was introduced by this mining law or mining code. So firstly, cases between the mine owners and the workers are excluded from the jurisdiction of the Council of Purgari and put in jurisdiction of the leaseholders of taxes. This development was probably due to the vast number of cases. Novo Brdo had 5,000 to 10,000 inhabitants at that time, and most of them were related to mining production in some kind of in some job related to mining production. And one single court, Council of Purgari, couldn't resolve all the possible disputes. Second direction of the judicial development was introducing the local voivoda in medieval Serbia. Namely, after the death of his brother and co-ruler, Despot Stefan, wanted to centralize his rule. That was Serbian ruler at that time who enacted this mining code. And the reason was, of course, of that militarization of authority, local authorities, and the reason of that was permanent danger from a bully neighbor, and bully neighbor was Ottoman Empire at that time. And therefore he divided the whole country in several military counties, and head of each county was voivoda. Voivoda was not only military commander, but also administrative and judicial authority, which is of the importance for this story. And voivoda was first mentioned 1410 in Novo Brdo. And according to the mining code, voivoda was also member of Council of Purgari. Additionally, he has his own jurisdiction. All the cases worth less than 1 liter of silver. And the reason was also the relief of the Council of Purgari, since there was just one Council of Purgari, so just one court of this kind in Novo Brdo. So this was also the last change in the judicial system of Novo Brdo mentioned in sources before the Ottoman conquest, which happened in June 1455. And with new Ottoman rule, of course, the judicial system was fundamentally changed, and therefore it cannot be considered as evolution or transition in matters of jurisdiction, and it will be not subject of this paper. And to conclude, the case of Novo Brdo was a good example to illustrate the transition of judicial system in medieval Serbia. By setting the foreigners not established in local feudal system, practicing a previously unknown profession, which mining was, appeared a lot of cases which were not covered by the jurisdiction of existing courts. And one may conclude that Saxon customary court, Council of Purgari, was introduced in medieval Serbia and Novo Brdo without written confirmation but via facti. And it was introduced since there was lacuna juris in judiciary system in medieval Serbia. Saxon customary court, Council of Purgari, as a collective court was in new surroundings extended and included some notable members of local authorities, archpriest, knez, and voivoda. At the same time, due to increasing number of disputes, of course, disputes of smaller value were distributed to other authorities in order to unburden the Council of Purgari, and cases between mine holders and workers were put under jurisdiction of leaseholders of taxes. And cases of values less than 1 little silver were put in jurisdiction of voivoda. And for the end, which is very interesting, all the mentioned development was occurred in period no longer than only 1 century. So thank you for your attention.